third submission is that the rationale for the exclusion of criminal proceedings or criminal cause or matter does not encompass, under the JSA, the present context. The evident and central concern of Parliament in relation to the criminal side of that divide was about the unacceptability of relying on closed and non-disclosed material in proceedings in which guilt or innocence of a charge brought against an individual by the state is being determined. Unacceptable politically, no doubt, and unacceptable legally under Article 6 of the ECHR.
That doesn't seem to be the thrust of the explanation given in the Green Paper, which is concerned very much more with the higher degree of control that the executive has over the continuance of criminal proceedings.
My Lord, in the references that we've given in our case to the Green Paper, there are references both to the concerns about Article 6 and the concerns about, or the fact that criminal proceedings involve accusations by the state. And so, yes, although my Lord...
But for the latter purpose, the relevant consideration seems to be that because it's an accusation by the state doesn't have to proceed with it.
Well, that's certainly true, and a function of it being the state that brings it. So the state can decide not to. So again, maybe that's a function, as it were, of the state being the party that makes the accusation. So it's always open to it to withdraw. That plainly wouldn't apply in the context of a judicial review where the state is the defendant. And we know that in certain purposes criminal charges can't be brought because they would depend centrally upon evidence which couldn't be revealed even in camera. So I wouldn't, I'm not sure for the purpose of my submissions, I would, as it were, mind if that was the flavour of the Green Paper, but I respectfully submit that that is simply a function of the fact that it's the state that's bringing the accusation against the individual, which is the point made in terms in the Green Paper alongside the concerns about Article 6 in effect not permitting closed process in that sort of process. What sort of process? The process to which Article 6, in which Article 6 would impose those greater safeguards. And one sees both of those themes. I'm not going to go to the Green Paper unless you wish me to, but both of those themes appear from the quotations we've given you in paragraphs 28 and 29 of our case. MS 2411, if you have them there. As you'll see when in para 28, when dealing with civil proceedings, the start of the second paragraph in that quotation within paragraph 28, by contrast, criminal proceedings involve an accusation by the state. And then the same theme in para 29, if one looks 3 or 4 lines down in the quotation, first paragraph of the quotation in para 29, under criminal versus civil, why criminal proceedings are outside the scope. Civil cases, courts adjudicate on disputes between persons in the civil law. In criminal cases, it's usually the state which prosecutes individuals. Understandably, more onerous requirements for right to a fair trial. Criminal proceedings have the strictest requirements under Article 6 ECHR.
What page do we find that on? Oh, sorry, here we are.
Yes, 1867. Sorry,
yes,
are you in the main body?
Yeah.
The statute might have referred to criminal proceedings and achieved that result, I suppose.
It could have referred to criminal proceedings, and I'm going to come back to that, because that might be thought is the analogue of criminal cause, and so you've got all matter to deal with, and the question is what that sweeps up. But my submission, you won't be surprised to hear, is that there were certain things which were not, as it were, the direct criminal trial, but which would fall foul of those sorts of, that sort of concern. Including, for example, extradition proceedings, which I think was the example my Lord Wilson raised.
But the explanation given, criminal versus civil, is definitely one which suggests you're looking at proceedings where somebody is accused and actually at risk, and where it would be inappropriate to use secret evidence, doesn't it?
My Lord, yes, and that is the core of it. I mean, I don't think anyone disputes that that is the core of it. If you are dealing with
yes,
a criminal trial,
Yeah.
then plainly that is covered. And the question is, how close are you to that rationale? The problem my learned friend has is that he hasn't got a rationale to put, as it were.
Well, the question is
on
put
his.
it can be put the other way around. I noticed that in the explanatory notes in the paragraphs we weren't referred to, but in fact, at paragraphs 51, the notes of the
67.
bill, and actually 79, I thought,
Oh, 79, is it?
to the Act.
Yeah.
It simply distinguishes between relevant civil proceedings, defined as proceedings in the High Court, Court of Appeal, Court of Session, or Supreme Court, which are not criminal proceedings.
Yes.
And that's all it says. But, I mean, what's your explanation as to what all matter adds?
My Lord, we respectfully submit in relation to all matter that it's designed to be a sweep-up of those matters which fall within that basic rationale. So it's not very difficult to see why, for the sake of argument, extradition proceedings would fall within that basic rationale. And we've given you a citation, I think, in footnote 7 to the case, on page 2416, to the reasoning of this court in B and others, the Rwandan case, to the fact that the district judge on extradition case has the same powers, or as nearly as may be, as a magistrate's court would have the proceedings of a summary trial.
So which footnote was that? Footnote
Sorry, footnote 7, page 2416.
Yeah.
But extradition proceedings might be thought to be an example.
Yeah.
The question in truth is whether, on my learned friend's case, that any connection, as it were, a connection with the criminal process, however light as it were, brings in the rationale on his basis. But my respectful submission is there's no support for or sense in that.
I mean, I think the thrust of the case against you, I think, is that the expression is designed to identify the excluded proceedings by reference to their subject matter rather than by reference to the procedural incidents. There are lots of circumstances in which in a criminal matter certain aspects may fall to be decided in what are technically civil rather than criminal proceedings in the High Court, for example. And the question is whether the legislature intended to draw the boundary line between proceedings with a criminal subject matter and proceedings which were classically civil on the one hand, or whether they intended to draw the boundary line between those aspects of a criminal matter which concern the direct decision on innocence or guilt, and those matters, those aspects of a criminal matter which were concerned with the kind of things that are decided in the High Court.
My Lord, I agree. That's how the issue, as it were, breaks down. And my submission, you'll understand, is that if one tries to identify the rationale for the exclusion of criminal, you start, as it were, with the dark heart of the matter. You start with the core of the concern that Parliament had. And it's evident that the core of the concern that it had, was that you shouldn't use closed material procedures where guilt or innocence is being determined. Now, the challenge that then arises on my case, I fully accept, is that you've got to build out from that to give some meaning to all matter. But all I have to do, I respectfully submit, is to identify a matter which Parliament might be thought to be including, e.g. extradition proceedings on my example, and then the fundamental interpretive analysis that the court undertakes is to test, as it were, those cases in the penumbra to see how close they are to the original and core concerns that Parliament had, rather than simply saying it's a big, broad division dependent upon subject matter, and classically it's things in the High Court, because then you're much more likely to end up with adventitious distinctions.
What is so special about extradition proceedings, other than the fact that they are a criminal matter in respect of which certain categories of decision have to be made in a civil court in civil proceedings, like habeas corpus proceedings?
Well, they involve a request from another state, which is, we would respectfully submit, classically criminal, because the individual is wanted to face a charge brought by the state. And when the receiving jurisdiction is exercising its powers, it is doing so qua state, in effect judging whether or not there is a case to answer of guilt or innocence.
Yes, but when you ask yourself what's the status of civil proceedings arising out of an extradition request, one would be inclined to say, well, it's all concerned with a criminal matter, and it doesn't make the slightest difference that civil proceedings are necessary to decide some aspects of criminal matters.
My Lord, you might be right. You might have some civil proceedings which are connected in that way, if we use the term broadly. But you then have difficult arguments, none of which anyone before you has gone into, as to whether or not that particular category of proceedings is on one side of the line or the other.
Well, habeas corpus is a civil proceeding.
Habeas corpus, I agree, is a civil proceeding. The question is whether things have changed under the Extradition Act 2003, or whether for this purpose you characterise that as more like criminal, closer to the heart of the rationale, or you just say, well, it's a big broad distinction.
Well, it's a civil proceeding, but it's not necessarily a civil matter if it relates to criminal proceedings.
My Lord, yes, but you have to ask the question. You have to ask the question in context. What is the nature of the concern, and what is the nature of the benefit under this piece of legislation in allowing, or in imputing to Parliament an intention to allow, a closed material process? And so if you have, as you do in our context, and it becomes a bit difficult to go too far beyond that, I understand one's got to deal with all matter, but there may be other contexts out there which would need to be argued through rather more fully. But if you ask the question in our context, for the reasons I gave before the short adjournment, there is a judicial review which is happening in the High Court. It's classically civil for that purpose. It's a judicial review, and so that has the civil flavour, as it were. It is connected with criminal process in the broad sense because it is a challenge to the decision whether or not to prosecute. So there is some connection. But the question is, why would Parliament have set its face, as it were, against the court being in the same position as the decision maker for that purpose? And so we respectfully submit that there is some real force well, perhaps in a note of caution, as it were, in approaching it too readily on the basis of subject matter, rather than the sort of approach that the court will have seen from the Fawaz decision, which is to look at the core function that the court is actually performing. What is the core function that the court is performing? And in our case, it is a classic judicial review function, and if CMPs are available, the court can perform that function.
If extradition is a necessary precursor to proceedings abroad, could one say that a decision to prosecute is a necessary precursor to the proceedings here? Is there a parallel?
My Lord, I respectfully submit not for this purpose, because if one focuses on the core function that the court is performing, here, of course it's right that there is some connection with criminal process. Otherwise we wouldn't be here. We're arguing about where that divide lies. So of course there is, and it is a precursor that the DPP, or whoever it may be, decides that a prosecution is appropriate if criminal charges are to go ahead. But in our context, the core function that the court is performing is the classically civil function of reviewing for lawfulness the decision of the executive. And that is a different function, we respectfully submit, to the function that the court will be performing when it is determining whether or not to extradite. My Lord, this isn't entirely new territory. Of course, these things always arise in a slightly different context, but we've cited, you've seen in our case, Lord Mance's judgment in the Tariq decision, which was handed down on the same day as Al-Rawi, paragraph 40 of that, drawing this basic distinction between the sorts of concerns that arise in a civil process, I'm using the word neutrally, and the sorts of concerns that would arise in a criminal process, to use the words neutrally. And that paragraph 40, setting out those different concerns, focusing in particular on the unacceptability of relying on closed process to prove a charge against someone, are useful and helpful as illustrating at least the core of this distinction. And then the question is, how far or how close are you to that core? That's how we put the argument. And that does, we respectfully submit, chime with the pre-legislative materials and their emphasis on accusation by the state prosecuting, and the strictness of the Article 6 requirements. And the list, of course, in criminal proceedings, as indeed in extradition proceedings, is in effect between the state and the private individual being subjected to the criminal purpose for the purpose of determining whether he goes abroad to face the charge or whether he is guilty or innocent under our system. And that is fundamentally different, we submit, to the position where the concern is, as I've said, whether the court can actually perform its judicially reviewing function.
Just going back to Fawaz, is it a curious case? Because we actually don't know what the facts were, really.
Fawaz?
Yes, Fawaz.
No, we don't, but we know the context was an MLA application.
Quite.
So the defendant in a US proceedings, if I've understood it correctly, was seeking to obtain material from the UK, from the Secretary of State, in effect, for the purpose of supporting a defence to US charges.
Yes, so that, and that's...
So we know enough, as it were.
That's where the Secretary of State refused to
So
exercise.
the Secretary of State says no,
yeah.
Then you go off, and you're within. True, that's not a bad example because you're in a criminal process, as it were, in that sense. Yeah. But the fundamental reasoning of the court, as I think you see from the back end of paragraph 7, was that the function of this court is a step removed from any proceedings which can properly be characterised as a criminal cause or matter. So there is as it were, a ripple out from the heart analysis to be done, and that's what's being done in Al Fawaz.
Well, I suppose the same problem could have arisen in civil proceedings in the States. Could it?
Yes, it could. You could have made.
I want the documents and the mutual legal assistance. Please help.
It could. I'm going to come back to slightly strange distinctions, if my learned friend is right, and maybe that needs to be added to the list. But yes. But if that's right in that context, if Al Fawaz is right, no one suggested that was not in that context a proper way of looking at the civil-criminal divide. If that's right, then so here also we submit. You're ensuring, focusing on the court's core function, that decisions are taken within the law. The outcome, as the divisional court pointed out in our context and in Al Fawaz, in this sort of JR challenge, the outcome can't be and will not be to decide criminal liability. It doesn't involve a criminal appeal or anything like that, where the cases and the arguments may be different. And there is no question of any breach of Article 6 if one has a CMP and a JR of this kind. And no one has ever suggested to the contrary. Indeed, they couldn't do because, and I'll come back to this, Section 14.2 of the JSA itself makes expressly clear, if necessary, I would add, because the HRA already applies, but that nothing in the powers in Section 6 and following should be taken to permit a breach of Article 6. And amongst other things, that has an impact on safeguarding, as you will know, because it opens up arguments that, in certain contexts at least, that the AF number 3 principle should apply and there's a minimum level of disclosure and all of that. But I'll come back to that on safeguards. But that rationale for criminal proceedings being out, we respectfully submit, they just simply don't apply. They don't have any application or analogue in our context. And the question my Lord Wilson asked of my learned friend was in the end unanswered, which is, why not in a case like this? So we respectfully submit that that is an important aspect when considering interpretation. That's the third submission. The rationale that apply to cut out criminal proceedings do not apply to the present context. And the fourth submission is that if judicial review of this sort of decision is outside the jurisdictional reach of the JSA, that would create a set of at least quite surprising differences. Civil proceedings are in, So in Belhaj civil, they can mount their claim for damages in a civil suit, and Section 6 is open. Mr. Justice Popperwell has made the declaration. There's no appeal from that. And so for that purpose, the court can examine the allegations about the involvement of, alleged involvement of government in the treatment that these individuals are said to have suffered, and can do so fully cited. So civil proceedings are in, even though the subject matter is identical, or the base of that is identical. Judicial review generally is in. So if they'd sought a declaration in JR proceedings that the government had acted unlawfully by allegedly so involving themselves, for example, under the HRA or under public law principles, then the Section 6 jurisdiction would run and the closed material procedure would be available. And yet not, on my learned friend's argument, if you are seeking to determine if a public authority making charging decisions has acted lawfully, even though you've got the same essential factual or allegation basis, and even though that sort of action involves the court performing precisely the same function as a JR of the very substantive action that founds all of this. And that is a very odd outcome, we respectfully submit, and one that it would be strange for Parliament to have intended. One can ask the question rather differently in the light of Haralambos, or posit a slightly different oddity in the light of Haralambos. We also know that by virtue of the words ex parte in the relevant statutory provisions governing the obtaining of search warrants, which was the subject matter of the Haralambos decision in the Supreme Court, that Parliament was content to allow, in effect, a closed material process when obtaining a search warrant, and then, per the Supreme Court's reasoning and conclusion in Haralambos, content for there to be a judicial review of that decision by the magistrates, or a judicial review of the Section 59, I can't remember which act of, but Section 59 revisitation of that issue in the Crown Court, even though it might be thought that context is much more closely related to criminal proceedings than ours. And if that is so, it would be very, very odd, we respectfully submit, if, given that all those provisions flowed from PACE, that they were prepared to accept that, but were not prepared to accept a CMP for the purpose of holding the executive within the law in this sort of JR. So we do respectfully submit, I'm sure we can multiply the examples of oddities, as it were, and maybe they do no more than illustrate the difficulties of the underlying policy position that my learned friend takes, and the difficulty he has of identifying why it should be on any sort of purposive or policy basis that this sort of process, brought after all by his client, seeking the relief of the civil courts to determine whether the DPP acted lawfully, why it should be that Parliament would have intended that the court should in effect be disabled from performing that function either at all or properly because it didn't have access to the same material that the DPP had. So that's the fourth submission, odd distinctions. The fifth submission I've already touched on, which is wording. The distinction effectively is drawn between civil proceedings and relevant civil proceedings and criminal cause or matter. And the submission that I make, I can take it very quickly because I've already dealt with it effectively, is that cause is apt to cover what I described as the heart of the rationale for excluding criminal. But it might be thought in context that Parliament can be taken to have thought, well, even outside that pure and central concern, there may well be other types of matter. And so we need something else, a sweep-up, as it were. But the nature and extent of that sweep-up is to be determined by how close it sits to the core concerns that I've identified. And as I say, I fully acknowledge that there may be difficult issues and difficult contexts in that penumbra as to precisely where a particular type of process sits. But you don't have to solve all of those issues in this case, and indeed it might be thought thoroughly undesirable to do so in some contexts without fuller argument. Your question is whether or not this sort of judicial review, with its connection in a broad sense with criminal process, because it's the precondition, as my Lord Wilson pointed out, is that enough to exclude? And we respectfully submit that for all the reasons I've given, that can't be. You focus on the core function that the court is performing. You ask why on earth Parliament should have wanted, in a claim of this kind, to exclude consideration of the same material that the decision maker considered. So those are the 4 or 5 positive submissions. Can I turn to the responsive arguments? And there are really two bits to this. The first of them is that Parliament deliberately reached for a phrase. Deliberately reached for a phrase. And the second of them is the principle of legality and PII. The linchpin of the claimant's argument, and it was really the sole focus of the argument, or the principal focus of the argument below, was that the phrase criminal cause or matter in section 611 has the same meaning as has appeared or might have appeared from the case law governing appeal routes. And the first answer that we give to that submission is that there is clear authority that the meaning of a phrase is dependent on the context in which it is used. That is a plain and well-established principle of interpretation. And if you wanted, unnecessary perhaps, but if you wanted a recent authority in which this court accepted that precisely the same phrase, even in the same legislation, could, as it was put in that case, point in 2 different directions, then Lord Mance's judgment in the Buckness EUC-NYS case at paragraph 31 is it. Supplemental authorities, tab 62. But it doesn't just, the submission doesn't just flow from that basic principle of interpretation. That principle, that it all depends upon the context, has been used, as you've already seen this morning, to provide a different meaning for the very phrase in question, criminal cause or matter. And the contrast that was before the court in the Guardian News litigation was between the use of that phrase in section 18 of the Supreme Court Act 1981 and section 68 of the Courts Act 2003. And can I invite you just to go back to that very briefly? I've been trying not to go back to authorities, but bundle 4, tab 36, MS 1080.
Sorry, could you give me that number again?
Yes, I'm sorry. Bundle 4, tab 36, 1080.
1080, yes.
It's the second of the Guardian News cases. It's the substantive issue. And the paragraphs we want for this purpose are paragraphs, well, one can see the lead in. Para 102 is really the start of it, on page 1116.
This is the tail end of the judgment, isn't it?
It is.
During the course of the hearing, we asked, Mr. Jaffe said that all this was really Mr. Perry making a big submission, but struck me, we asked, perhaps this was a query from the court. So it's dealt with pretty summarily. There's nothing in the printed argument of counsel about it, I think I'm right in saying. And so it's light fare.
It is like fare, my lord, but perhaps I don't need heavy fare for the basic proposition, of which this is simply an example. The only reason it has some compulsion behind it is because it's an application of the basic principle to the very phraseology in question. And for that forensic purpose, if no other, recognising entirely the lightness of the fare, we place little reliance upon it, as well as the distinguished nature of the court, of course. Paragraph 106. Is really the guts of it. And then my Lord Neuberger agreeing with that in paragraph 110. And it might be thought that if the reasoning of the court in that context, and assume for the sake of argument, despite the lightness of the fair, that their conclusion is correct, it might be thought that the distinctions between, on the one hand, Section 18, the appeal route provision, and Section 68 of the Courts Act, on the one hand, and on the other, the present contrast between Section 18 and the JSA, if anything, our distinction is all the more pronounced in terms of basic and fundamental context and purpose and the different things that gives rise to. And it does lead to the slight improbability, or it leads to two things that need to be noted in relation to timing. The first of them is that this judgment was handed down on the 3rd of April 2012. If one's casting one's mind or one's position into the mind of the parliamentary draftsman and Parliament considering this bill. This judgment is handed down in April, beginning of April 2012, and the JSA bill is read for the first time in the Lords a little under 2 months later, on the 28th of May 2012. So if you're looking to see what Parliament thought about the meaning of criminal causal matter and whether or not it had some sensible meaning which was consistently applied and could be taken, 2 months before they start considering the bill, you have a decision which says it all depends upon the context. Here's the very phrase in question, and depending upon the underlying purposes of the legislation you're considering, it can mean fundamentally different things. And that is, we respectfully submit, what parliamentary draftsmen would have had in mind at the time. It's also very difficult, we respectfully submit, to see how it can be argued that Parliament did use the phrase differently to Section 18 and the appeal route case law when enacting the Courts Act, see Guardian News, but then, as it were, reverted to original 1981 definition with all the complication that seemed to involve when it got back to JSA 2013. So we respectfully submit that the principle in Barras and the basic principle of take a phrase, must be assumed to know what it means and ascribe that meaning, that just simply doesn't work in our context, because parliamentary draftsmen will be taken to understand that the words take their meaning from the context, and they will understand that very directly in relation to this very phrase, because 2 months earlier there was a case that said that. And I don't think any of that turns on the lightness of the analysis in that case. It's just simply the outcome. That's a submission. So that's the first submission, as it were. The second submission on Barras and plucking a phrase out is that even if you assume in principle that there is really a hardline principle of some kind set out in Barras, and I'm not going orally to develop the points we've made in 52 to 54 of our case about the caution with which the courts have approached that principle in Barras, but let's assume for the sake of argument that it has legs, as it were. It has understandable preconditions. It is much more nuanced than the appellants suggest, and it isn't close to some sort of rule, as it were, that the same meaning must be ascribed to the same wording irrespective of context. And the preconditions, we respectfully submit, are to be found in the speech of Lord Buckmaster. Don't invite you to turn it up now, but from the Barras decision, we've set it out and quoted it in our case at paragraph 51. Page 2423 on the MS numbering. And the two key conditions, as you see from that quotation at para 51, are that the phrase must have received a clear judicial interpretation and the subsequent statute must be in a similar context.
Well, your second point is obviously important. So far as you're emphasizing clear judicial interpretation, Mr. Jaffe says, well, there may be a lack of clarity at the edges, even in the appellate line of authority, but there's really no particular doubt that this sort of case falls within the criminal rubric.
Well, my lord, the answer to that is Guardian News, 2 months earlier. You had exactly the same phrase, and it's being given different meanings. And all what my learned friend then says is, yes, but in relation to a decision to prosecute, there is some authority of some antiquity that might suggest that the appeal route on criminal cause or matter applies to that sort of decision-making. And he is perfectly entitled to point to cases like Pretty and Corner House. But in both of those cases, the argument was not had, a bit like here. The point, for whatever reason, was simply, as it were, assumed. And so there isn't any clear or compelling authority that even in the appeal context, decisions of this kind are necessarily within. And you will have seen the argument that was run at some length by the DPP below in relation to that, whether truly this sort of decision did fall within it. But there's at least, therefore, some doubt about that. But our big answer is context. My lord is right. And we submit respectfully that that is a sufficient answer. And one can test it against the facts of Barras. Don't need to go to them now, but if you go back to Barras, you'll see that the question that was really being, or the comparison that was being made there was between two phrases, both of which were an identical wording, which said wreck or loss of a ship. And the question is, what did a wreck mean? And they'd applied a particular meaning to the word wreck in 1913 in a case called the Olympic. And so when Parliament used that phrase a few years later in the Merchant Shipping International Labour Conventions Act of 1925, it was not very difficult to see why they assumed that it meant the same thing, the concept of wreck. If, on the other hand, you are transposing between a context which asks what is a criminal cause or matter for the purpose of appeal rights, as compared to what is a criminal cause or matter for the purpose of opening up this jurisdiction, if you pose the question in those terms, it's not very difficult, we respectfully submit, to see that the context, at the very least, might admit of very different answers. That's how we put it. So that's my reach for the same phrase answer, or set of answers. Principle of legality and PII, can I turn to that? My basic and core submission in relation to the principle of legality, and whether it's put on the basis that it is not in play or it's put on the basis that it doesn't apply in the same way, matters not, I respectfully submit. Core submission is that here, and in this legislation, fundamental rights are being balanced by Parliament. They are not being overridden in that sense. Of course we accept that there is encroachment into and impact on the principles of open and natural justice if a CMP is adopted. That is entirely evident and was confirmed by this court in Al Rawi. But that encroachment and impact, firstly, flows from the facts that the material in question cannot be seen and disclosed in public without damaging national security, and under the Act only national security. And so you can't see it, it's not possible to disclose it for good reason to do with the protection of the public. And you wouldn't see it under the common law doctrine of PII either. And the encroachment or impact flows also from the fact that the context of this sort of JR decision, and indeed other decisions raising national security sensitive material, involves a decision by the decision maker where the decision maker could and did take into account that material, and a context in which the claimants have chosen to challenge the legality of that decision. It's also to be noted, and we respectfully agree with my Lord Lloyd Jones, that this is a context in which we are considering a jurisdictional issue for the purpose of the principle of legality. And that is relevant because, viewed in that way, the decision about what falls on which side of the line can be viewed, if you will, as a gateway decision. The court will actually only order and can only order Section 6 or make a Section 6 declaration in circumstances in which the preconditions laid down by Parliament are satisfied. And they include the court being satisfied that it's necessary in the interest of the fair and effective administration of justice in the proceedings to do so. So the premise, as it were, for overriding rights is that Parliament has imposed the precondition that says only do it if it's necessary for effective and fair administration of justice. And of course the context, I'm not going to keep banging the drum, but the alternatives are, at least in quite a number of these cases, particularly when one's dealing with national security as the precondition, which are at the very top of the PII tree, as it were, we are dealing with a context in which the alternatives are likely to be more intrusive into the fundamental principles which the courts hold dear, actually able or unable to resolve the disputes. Effective judicial review of the kind described by my Lord Manson, Harold Lambos. Judicial review on the basis of the court being able to view the underlying material that the decision maker had before them. And judicial review in the end, and at its highest and broadest, protecting the engine of the rule of law by holding public authorities to legal account. And the concerns that were identified in Al-Rawi, bear in mind, were concerns that led the court to a conclusion that they couldn't do it. Parliament needed to do it. Of course it is right that in all the paragraphs the core reason why they couldn't do it was because of the encroachment on those, as they described them, fundamental principles. But they were not saying, the court was not saying in Al-Rawi, that if Parliament did choose to do it, that would be fundamentally unfair, that would encroach on fundamental principles. Indeed, that is not what they've thought, is entirely evident from the Tariq decision handed down on the same day, which did have legislative authority in the form of secondary legislation in the employment tribunals, and where the court held that, in effect, Article 6 didn't require, as a matter of fairness, a minimum level of disclosure. But so one needs considerable caution, I respectfully submit, before jumping from the references to encroachment on fundamental principles in Al-Rawi, leading them to the conclusion that the court couldn't invent it, Parliament would have to grapple with those issues and make the decision if it wanted to a conclusion that, therefore, having done that, the courts would view this sort of balancing and process, once Parliament has considered it and enacted it, as itself unfair. That is, that we respectfully submit an illegitimate leap. And it's perhaps entirely unsurprising in Al-Rawi that the court did so decide, because not merely were there concerns about encroachment into open and natural justice, but there was a self-evident need in the court's view, as one sees from the judgments, for Parliament to consider the balancing of the various interests. How do you balance? What is the solution to the dilemma, the paradox that I have been placing before the court, where it's an encroachment on one side, as it were, but the consequence may be something worse. How does one do that? And if one is going to do that, what should the preconditions be? Well, we now know, see section 6.5 amongst others. What should the safeguards be? How should those interests be balanced? Those are fundamentally social decisions which Parliament is entitled to take and which the court in Al Rawi placed into the hands of Parliament. And it might be thought, just before coming to the safeguards very briefly, it might be thought that the fundamental rationale for the principle of legality is also not present in our context. Normally, if I can summarise, the courts use the principle of legality to make the government or Parliament take the political heat. You can't legislate in general terms and then produce, as it were, underneath that, something which interferes in a serious way with fundamental rights. If you're going to do that, you've got to be upfront about it. But that is just simply absent here. Because the very reason that Parliament legislated in the Justice and Security Act 2013 was because of the dilemmas that I described earlier and because of the court's decision, including its references to the concerns that it had in Al Rawi. That's why they legislated. They legislated in the full knowledge that this was the game that was afoot. This was the balancing that needed to be done. And finally, in relation to this part of the answer to principle of legality, safeguards. My learned friend was dismissive of the safeguards under the Justice and Security Act and presented it as though it was the tiniest thing. Once you're in, no balancing at all of fairness against national security, none of the safeguards that one gets in PII. I'm going to come back to that directly in a moment. But it is just worth bearing in mind the nature of the safeguards that Parliament saw fit to introduce when it introduced this scheme, because that does help, as it were, counterbalance the idea that the Act itself is to be taken as having overridden fundamental rights, common law or the ECHR. And if you go to the Act, if you would, number 1, tab 2, I think. Page 11 in the MS numbering. And the preconditions, we respectfully submit, are absolutely key. I'm going to come back to the use that can be made of PII in a moment, but you see the relevance condition, section 6.4. In other words, the court needs to see the material before it would be otherwise disclosable, before it can be admitted. But then 6.5, which is absolutely at the heart of the protective scheme, heart of the safeguarding. And if I can summarise, given the timings, if I can summarise rather than take you to the case law that has developed. I gave you in our case, I'll find the paragraph in a moment, but a series of cases in which the application of all these various provisions has been thought about with care by the courts below the level of this one, working out what the safeguards are and how they work and all of that. But in relation to 6.5, the position in a nutshell that one has ended up in, the decisions in question are summarised or collated, as it were, in paragraph 21 of our case. So those are the ones that, if you want, as it were, an in to how the Act works, those are the ones to go for. But the position, so far as 6.5 is concerned, if we just pause there, is that regular and repeated attempts have been made to make the argument that my learned friend has made today, which is that PII needs to be done first, it needs to be more than considered, it needs to feed in. And ultimately where the courts have got to is to reject that. They say that to make PII happen first would be fundamentally inconsistent with the scheme of the legislation. But they have said, when you come to consider 6.5, you can, as it were, think about whether PII, you as the court, I mean, can consider whether PII would be a more obvious alternative in the circumstances of the individual case. So it isn't excluded. The Secretary of State only has to consider it, C6.7, but the court can also think about it when exercising its discretion under Section 6, and in particular in concluding whether it is or it isn't in the fair and effective administration of justice in the proceedings. See, for that purpose, in particular, Sarkandi, and also XH, which was the Lord Justice Burnett and Mr. Justice Cranston decision. And on that point, the relevant paragraphs for the purposes of XH are 15, it's in Supplemental Authorities, tab 70, paras 15, 18 and 19, in particular 19, on page 2283. So PII comes in there. True it is that under Section 6, for understandable reasons it might be thought, the court is invited to make the declarations on the basis of a sample of material. So you don't have to produce every document at the Section 6 stage that would otherwise be disclosable. To take the RORW context, that would have been an enormous exercise and task. The question is whether the court needs to go into closed for the purpose of determining how the open-closed divide should then be dealt with. So it's done on a selection of material. But the matter doesn't end there. If you go forward in the legislation, so back to tab 2 and bundle 1, the court, as you see from 7.2, is placed under a specific obligation to keep the declaration under review as the proceedings progress, and may at any time revoke it if it considers it no longer satisfies the Section 6.5 condition, in a nutshell. And it's required to undertake a formal review at various stages. See, for example, Section 7.3. So it isn't a once and for all. It gets you through the door, and then you have a full-blown process, as it were, which considers whether it's necessary, and if it is necessary and continues to be necessary, considers all the options relating to disclosure, driven by the fundamental principle that, subject to the protection of national security, everything that can be made open should be made open. And that is the Section 8 process. So under Section 8, you get a flavour of what the rules provide. We don't need to go to the rules because the enabling provisions are, Section 8 is fundamentally an enabling provision, but you see the nature of the rules from the provisions which enable them. And they include, in particular, sections 2 and 3 in particular in Section 8. So what the court does, and it does it, by the way, with the assistance of the Special Advocate, see Section 9, is to do what SIAC has been doing for quite some time, which is to look at the material which is presented in closed and over which national security is claimed, the totality of it, and it asks itself the question, is there a good damage to national security case? I'm summarising the steps, but this will be familiar to many of you. Is there a good national security case? And is there any possibility of summarising the material? And if there isn't, and the thing has to be protected, the material in question has to be protected, then they have to start considering the options in Section 8.3. And if
Mr. Reedy, I have made the assumption since 235 that actually you and Mr. McGuinness have decided that you're going to take the lion's share of the
I am.
Of the
we
time.
have.
Yes.
If that's right.
Otherwise, I would have stopped you ages ago, but
Yeah.
I was so riveted by what you were saying that, of course, I didn't.
My lady. Yes. I was going to show you one paragraph in one authority. Supplemental Authorities, tab 66. MS 2173. just to try and encapsulate the flavour of what actually happens under Section 8. This is the McGartland decision, which was handed down on the same day as Sarkandi, with Lord Justice Richards giving the lead judgment in both cases. But I wanted to show you, just to give you a flavour of how this part of it works, paragraph 48.
Sorry, Mr. Reed.
Yes, I'm so sorry.
Tab 67.
Tab 66.
66, thank you.
66, page 2190,
Yes, thank you.
para 48. So you see that link between Section 6 and Section 8 and how the Section 8 process works.
Sorry, paragraph.
48,
Thank you.
2190 at the bottom. I only go there because it's just a helpful, as it were, and pithy encapsulation of the nature of the process as the lead between 6 and 8 and how the Section 8 process then works and all the safeguarding that Parliament has carefully built into the scheme. And just to go back to the Act and the final provision I was going to show you, I've referred to it already, Section 14 on page 19 in the MS numbering, Bundle 1, Tab 2, back to the Act itself, Section 14.2, which I think Lord Justice Richards may have referred to there. Page 19 on the MS numbering behind Tab 2 and Bundle 1. Nothing in Section 6 to 13, that's this whole scheme, is to be read as requiring a court or tribunal to act in a manner inconsistent with Article 6 of the Human Rights Convention. Again, it might be thought that's a bit like the free press provision in the HRA. It might be thought to be a little unnecessary, but there it is to bang the drum. And of course, practically what that leads to is a reinforcement of the idea that at least in some contexts, you will have what my lady will well recall as being the kind of AF number 3 approach, where there is a minimum level of disclosure and the sort of issues we were discussing in Tariq. But all of these safeguards are built in to the process, and we respectfully submit that that is a factor when you come to consider whether fundamental rights are truly being overridden, to use that word, or the degree and extent to which they're being encroached upon, if one prefers that as the concept. And it all feeds into the idea that which I've respectfully submitted already, which is that al-Rawi can't be taken as indicating a conclusion by the court that were Parliament to act, the scheme it then enacted should be taken as being unfair. They were simply...
Well, when he says that about 4 lines from the bottom of 2190, then the court can be expected to refuse permission for the material to be withheld to that extent whilst still giving permission for it not to be disclosed on any wider basis. That would be a common law file, would it? That's not under the Justice and Security Act, is it? That's not going to the lengths of a closed material proceeding because it's good enough to have a confidentiality ring. 4 lines up. I suppose the sentence begins about 7 lines up.
about confidentiality rings, you mean?
Yes, isn't that a sort of...
I think that, is that not provided for under the rules?
Is that provided for in the Act, that you can...
Confidentiality rings?
Didn't you have one? No confidentiality ring.
No.
I mean, he says, if, for example, the court concludes that otherwise sensitive material could be disclosed to the claimants and their open representatives on terms as to confidentiality and or hearings in private, without damage to the interests of national security. So he must be outside the Justice and Security Act there. This is a suggestion of a procedure at common law.
Yes, I'm not sure whether that's provided for under this scheme or not, or quite how that was approached.
I don't think it's in the Act.
No.
So this is an interesting passage because it really links the possibilities at common law with the possibilities under the Act. Yeah. Anyway.
My Lord, consistent, we respectfully submit with the theme, as it were, which is that the court is here trying to ensure as much openness as possible without damaging the fundamental interests which have led to the enactment of this.
We don't have the rules, do we?
We do in the bundles. I haven't referred to them at anything. I'll find you a reference. Tab 60. 60, in volume 6.
Yep.
Yeah. And you'll have picked up in 8.2 the requirement to make concessions if that's what the court decides is appropriate, because the material can't be disclosed.
So does Lord Manse's question lead into your dealing briefly with the idea of ultimately, possibly, a consent-closed material procedure?
My Lord, it does. Can I come to that when I deal with PII very briefly, which I'm
Very
just
well.
about to do? I want to do one more thing before I get there, if I may, which is the lesser argument, or a similar-looking argument, has been run on a variety of different occasions, including in the Sarkandi case and in the Belhaj Section 6 case, which is to say that because of the concerns expressed by the court in Al Rawi and my learned friend's assertions about how this is an unfair system, as it were, the argument that has been mounted is that you should approach the terms of the JSA in a way which is presumptively narrow. In other words, you should narrow the scope for CMPs, narrow the nature of the test before you can get through the Section 6 door. And that has been consistently rejected, and consistently rejected in effect for the same reasons. And those reasons are that the Act was precisely Parliament's considered and balancing reaction to the various interests and concerns that I've identified, including the concerns identified about encroachment in Al Rawi. It's balanced them up and it's produced a solution. And you can't take, as it were, one side of the balance that fed into this nuanced solution and then reverse engineer it back in again to say, therefore, you interpret these provisions in a narrow way. So the clearest expression of that approach is in the Sarkandi case, volume 4, tab 47, MS 1582. Sorry, that must be bundle 5. Yeah, volume 5, sorry. Volume 5, tab 47, MS 1562 is the first page. And the relevant paragraph for this purpose, this was the one that was written at the same time as Gartland, is paragraph 58 on page 1582. So you see the argument being mounted, the argument being run, and the argument being rejected. And could I invite you just to write next door to paragraph 58 there, see also Mr. Justice Popperwell in the Belhaj Civil Section 6 case, Bundle 2, tab 15, para 26. I turn then briefly to PII and finally to PII. And our respectful submission in relation to PII is that PII does not assist him. The submission appeared to be that PII is a much better answer. It's the general submission that's made against me. We respectfully don't agree. It also involves departures from principles which the court holds dear, and it leads to precisely the risk of, as it were, greater damage to the rule of law that I identified earlier. It's an exclusionary principle, and it can and has been held to lead to the lack of ability in a court to resolve issues, including issues in judicial review, where it might be thought to be thoroughly important that the court holds the executive to the account, to account for the purpose of protecting the rule of law. We're all agreed, I think, that we haven't reached the stage, so that section in my learned friend's case, and which he ended on orally, about how clear the answer might be that the PII is going to fall in his favour, our answer to that is we simply haven't reached that stage of considering factual points in this context as to whether matters could or should be revealed, or the justifications for the national security concerns. And so one can't go too far down that road, but we have already noted, in relation to precisely the same underlying basis of fact and allegation, Mr. Justice Popperwell's conclusion on national security in paragraph 59 of his judgment on the Section 6 application in the civil proceedings. And it cannot therefore be assumed that PII, indeed rather the contrary, PII is likely to lead to any greater disclosure than a CMP. And any other points that can be made on security or the balance, whether or not it's necessary to protect, whether NCND continues to work, all of that, as you saw from McGartland and para 48 that I took you to, that can all be dealt with within the closed material process itself, and as an integral part both to the Section 6 application and to the Section 8 application. And we know, I took you to it earlier, that under Section 6.5, PII can be considered by the court, albeit that it isn't a requirement for PII to have been done, because that would be inconsistent with the statutory scheme. So we respectfully submit that it can't be assumed that PII is going to be any better for my learned friend at all in this respect. And moreover, we respectfully agree with the point that I think was put to my learned friend in argument this morning, which is that PII and its being either better or worse or the same as the CMP in this sort of respect, it simply doesn't bear on the distinction under examination. The distinction which you are considering is the distinction between civil and criminal. And if it is or may be more helpful to my learned friend, let's assume that for the sake of argument, it is or may be more helpful across the board of civil and criminal. It isn't intrinsically likely to be more helpful in cases falling on the criminal side rather than the civil side or vice versa. But we respectfully submit that, if anything, PII and the case that's now advanced on PII and Section 6 are positively unhelpful to my learned friend's case on interpretation. They now say, hold that this is criminal, and so no Section 6 is available in principle on the jurisdictional grounds, effectively. The consequence will be PI, which they think wrongly they will do better under. Then if they don't like that, they can consent to a CMP, so they can have their PII cake and eat it when they come to the CMP if they don't like the outcome. That rather suggests that what we're really dealing with here is not a principal concern about drawing proper distinctions on jurisdictional grounds, but seeking litigation or perceived litigation advantage. But we respectfully submit that that position is also incoherent. If it is criminal, as my learned friend's case asserts, if this context is criminal, it is outside the reach of the Act. And so that process, subject to consent, simply doesn't work as a sequence. It's flawed because it assumes that PII can't be considered under the processes of the Act anyway, and it's flawed in assuming that PII will deliver some sort of lesser encroachment. But it is fundamentally problematic to say that if he is right about it not being covered by the Act, he could then come back and consent to this sort of process being undertaken. There was debate, it is right to acknowledge, in Al Rawi about whether consent would or would not be available under the old system. My lady is nodding knowingly, and I'm sure my Lord Mance is as well. But there were at least different views about that in Al Rawi. And I think it's fair to say that my Lord Mance and Lady Hale went furthest, as it were, down that road. There was then a resurrection of that issue, as I mentioned earlier, in the AHK case, before Mr. Justice Ouseley, Bundle 1, Tab 8, page 88, paragraph, conveniently, 88. So 1 and then lots of 8s. But there is a quite significant analysis there as to whether or not pre-JSA you could have by consent that which, as it were, you couldn't have by imposition. It must surely be the position, we respectfully submit, that that argument in favour of consent being available has become very much more difficult now the Act has been passed. We know that the Act in its totality applies both, or deals with concepts that apply across the board, both civil and criminal. So the definitions in 6.11 encompass civil cases and criminal cases and ask you to draw that divide. But it is, what that tends to indicate is that across the range of proceedings, civil and criminal, this Act is legislating foreclosed material processes with all the complexities, all the safeguards, all the necessary empowerment for the appointment of special advocates and the weighing of those back. It covers the field, if you will. So how sensibly can it be said, on my learned friend's case, this is criminal, and so Parliament has deliberately on his case, and advisedly and intentionally, set its face, because it is criminal, against the CMP in this context. But nevertheless, you can overcome that and ignore that, and do it all by consent, if it suits him, because he doesn't get what he wants under PII. So we respectfully submit that the interposition of the legislation makes the argument for consent, which was, we respectfully submit, and of course recognising the force of the reasoning in my lady and my lord's judgments in Al Rawi, we respectfully submit that whether right or wrong, that argument has become impossible in the light of the passing of the Act with its coverage and its regulation, with all the sophistication that you've now seen in this legislation. And so just by way of conclusion, if I may, leaving aside all other difficulties, we submit that there is no justification in policy terms for my learned friend's key argument, which is, and core assertion, which is that Parliament must have intended the appeal route meaning to be applied. They simply don't advance a justification for that. And the factors that might have been in play in relation to that appeal route, in relation to this sort of decision, have no reflection whatever into the present context. So that primary way of putting it is lacking any sort of purposive or policy underpinning. One can go further what policy, one can ask rhetorically, justifies splitting out this category of judicial reviews? You're still challenging the lawfulness of a decision by a public authority. You're still doing so on classic public law grounds. The court is still performing its classic judicial review function and holding the executive within the law. And this is a claim which is brought by a claimant seeking the court's assistance in doing precisely that. Why should Parliament split off just this sort of decision simply because it could be said to have some connection to the criminal process? That outcome, we respectfully submit, would create a divorce or a separation, as it were, from any of the purposes for which CMPs can be taken to have been set up. And, moreover, divorced from the core of the concerns that led them to exclude crime. And those are questions that are all the more pressing and unanswerable, we respectfully submit, in circumstances in which Parliament has set up the scheme in this carefully crafted and safeguarding way, including the safeguard which for present purposes is the core one, which is that the court decides, and this is the premise on which the jurisdictional issue arises, the court decides that such a process is needed in the interests of the fair and effective administration of justice in the proceedings. So for all of those reasons, we respectfully submit that the divisional court was right in the conclusion they reached, essentially for the reasons they gave. My lady, my lords, those are my submissions.
Thank you very much indeed, Mr. Ricky. Mr. Watson?
Lady, my lords, I think I've got 8 minutes. 10 minutes.
You could have a little bit longer than that, should you require that. Mr. Jaffe went on longer than he was intending to, about 5 minutes. Anyway,
Lady,
let's not waste time on that.
Lady, my lords, the Director adopts the submissions that you've heard from Mr. Eadie. There is nothing we wish to add to them. You know from the history of the proceedings below that the Director engaged with the appellants on the meaning of the phrase "in a criminal cause or matter" in respect of the various statutory provisions that provide routes of appeal. And we lost, and we have not cross-appealed. And therefore there's nothing in terms of substance on that point that I wish to address the court on. All that the Director has really added to this appeal, and which Mr. Jaffe touched upon in his submissions this morning, is that we have given some examples of cases where, if the court accepts the submissions that have been made on behalf of the Secretary of State, the JSA closed material procedure would be of significance in what in fact are practical situations. Obviously the examples we've chosen are theoretical, though the third does bear a resemblance to the facts of this case, I acknowledge. But these are the types of case that the Director and the Crown Prosecution Service has to struggle with. And can I deal with them briefly? They're set out starting at the bottom of MS page 2748. And I just want to address the submissions that Mr. Jaffe made in respect to them, because he indicated that in respect of all three there was an answer. The Director submits that the answer that he has provided in respect of each of them is really not an answer at all. If one takes the first example, the registered informant case, my learned friend's suggestion was, I think, twofold. Firstly, that there could be a decision to defer prosecution until the ongoing terrorist investigation in respect of which he was providing information had ended. However, the example is deliberately chosen because the informant that is predicated here is an informant who's an ongoing informant who has in the past, is at present, and is anticipated will in future continue to provide information of assistance to the authorities. And therefore the explanation of, well, we will prosecute him, but we will prosecute him, it would have to be at some unspecified date in the future, because clearly there could be no reference to the matters in respect of which he's currently providing assistance. And any such explanation, even if coupled with something vague along the lines of it is not in the public interest to prosecute him at present, is only likely to beg more questions than it answers. And any information that would be provided on these facts to the complainant could not be provided in real life without the authorities first consulting the informant in question and effectively having to obtain his consent, because as the court knows, informants are effectively promised that anonymity will be guaranteed and that nothing will be disclosed that could lead to their identification. And in those circumstances, it's difficult in the real world to envisage what sort of disclosure could be made by the director to the complainant. One of the suggestions that my learned friend made was that there could be some sort of confidentiality ring. That sort of concept is not known of in criminal proceedings. A very straightforward example, as the court will know, when in Crown Court proceedings, the prosecution makes an ex parte application to the trial judge because it has material in its possession which is sufficiently relevant and either sufficiently undermines the prosecution case or assists the case of the defendant that were it not for the public interest consideration, that material might have to be disclosed to the defendant under the 1996 Act. In those circumstances, the application is made ex parte. It is not made in the presence of counsel representing the defendant, because it's very clear in the criminal sphere that counsel cannot, consistent with his duty to his client, participate in such a process. And therefore, the director submits that, in respect of the first example, my learned friend's suggestions, interesting and attractively put as they are, wouldn't in fact answer the difficult questions that the example poses, and deliberately chosen for that reason.
I thought his main point on the first one was a slightly different one, that the same dilemma can arise outside the scope of national security situations. For example, if this was an informant on a gang of drug dealers.
Yes, it would. We've chosen this example because, at least in this particular example, because it is a terrorist investigation.
But I mean, the fact that his example shows, doesn't it, that you can't, there are some things which there just aren't an answer to.
Precisely, my lord, there are not, and this is one of them.
Yes, but if there isn't an answer in other situations, maybe there isn't a complete answer in the context of national security. There's only an answer if it's a civil proceeding.
Well, it has to be national security, otherwise
yes.
one can't...
But it also has to be a civil proceeding, which is
It does, yes.
Yeah.
The second example, well, of course, as far as the second example is concerned, we're not in JSA 2013 territory unless there is some interest of national security that might be damaged. Now, that may come about because of the unconnected investigation that is there referred to. Unless the unconnected investigation has a national security angle to it, then, of course, the 2013 Act would not be engaged. But if it did, then on my learned friend's argument, the provision that we have, if the court has the REPA printout that was made available at the beginning of the proceedings, On the facts of this case, the ability to make disclosure, which is set out in section 18(1)(g), which my lady and my lords will find at the top of page 3 of the handout. That disclosure could not be made on my learned friend's submission. His answer to that was to refer the court to subsection 7 of section 18, which starts at page 6 of the printout, and he referred to disclosure being made to a relevant judge. The director submits that that subsection 7 would not in fact be engaged in this particular case, because you have to look at subsection 7 as a whole, and it begins by stating that the general prohibition on disclosure doesn't apply to a disclosure to a person conducting a criminal prosecution for the purpose only of enabling that person to determine what is required of him by his duty to secure the fairness of the prosecution, and then B, a disclosure to a relevant judge in a case in which that judge has ordered the disclosure made to him alone. Now, the reference to the relevant judge in a case clearly contemplates proceedings in court, and that is supported by the reference in subsection 8 back to the relevant judge. He shall not order disclosure under subsection 7b, except where he's satisfied that the exceptional circumstances of the case make the disclosure essential in the interests of justice. And where he is so satisfied, what the relevant judge can then do is set out in subsection 9 of section 18. In any criminal proceedings, the relevant judge may order disclosure under subsection 7b, that's disclosure to him, and in consequence of that disclosure, where he's of the opinion that there are exceptional circumstances requiring him to do so, he may direct the person conducting the prosecution to make, for the purposes of the proceedings, any such admission of fact as that judge thinks essential in the interest of justice, the caveat being in subsection 10 that nothing of any direction under subsection 9 shall authorise or require anything to be done in contravention of section 17. So unless there were proceedings in court with a prosecutor, the procedure that is set out in subsection 7 could not be used, the director submits. My lords, can I move finally to our third example, set out at the bottom of page 2749, which is close to this case. As the court has been told by Mr. Eadie, there are in fact 5 grounds of challenge in the judicial review proceedings that have been commenced against the director. 4 of them can be litigated in the conventional way before the High Court. It is ground 3, which is a challenge to the decision that the director made under the code of the prosecution code, that the evidence was such as not to provide a realistic prospect of conviction. Now, it follows that those sorts of decisions are inherently fact-specific, very fact-specific, and they require a consideration by the decision-maker of the detail of the evidence that is available. That is precisely what happened in this case. Mr. Mr. Jaffe referred the court to the director's letter, which we can find in the appendix starting at MS page 2690 and at 2692, just before the section at the bottom of that page, which Mr. Jaffe referred to, we see in the paragraph above that the letter said the security marking of the potential evidence in this case is such that I am unable to provide you with a summary of the material submitted to us. The view that is there taken is that it is impossible, because of the interests of national security, to summarise the very evidence that has led to the fact-specific decision that the code test is not passed. It is extremely difficult, if not impossible, for the High Court being invited to judicially review that decision on the basis that the director has made an error in law and that the code test was satisfied. It is difficult, if not impossible, to see how the High Court could possibly put itself in the position of the decision maker without having, via a closed material procedure, access to the very material which was central to the decision that was made in that case. And it is difficult to see how, in PII terms, for example, any form of summary or gisting that could be made available to the appellants would meet that. I accept, of course, that if there is a closed material procedure, that Section 8, subsection 1, paragraphs D and E, which we will find at MS page 13 and 14, will permit the High Court, as appropriate, to order, in this case, in fact, it would be, I think, the Secretary of State, to disclose a summary of the material, provided, looking at paragraph E, that the court ensures that such a summary does not contain material, the disclosure of which would be damaging to the interests of national security.
Mr. McGuinness, I must warn you, you're now well over time.
In fact, my lady, that's my very last point.
I thought it might be.
So as far as example 3 is concerned, Mr. Jaffe's submissions wouldn't cut the ice.
Thank you very much indeed. Mr. Little? Mr. Jaffe.
My lady, I'll respond first of all, if I may, to the suggestion that my clients are seeking a litigation advantage. I hope I'll be forgiven for saying that the appellants aren't here just for the fun of it. One of them, this country is not Libya, and CMPs are not available in a criminal trial, but one of my clients was subjected to a criminal trial at which he was excluded for most of it. My clients do have a real concern as to whether or not it is truly necessary for there to be a CMP in these proceedings. They're not seeking a litigation advantage, they're simply seeking to avoid it and to have a fair trial of the issues that are before the divisional court to the extent it is possible to do so. And I hope that their case has been presented realistically, recognising that PII ought to come first, but in extremis, the option of consent is available.
But if it's not really necessary, it won't go through the Section 6 hurdles, will it, Mr. Jaffe?
Well, it's right that I'll deal with that, because it may go through the Section 6 hurdles, because there was no response to the submission which I made that Section 6, subsection 7, does not require any consideration of whether or not PII would succeed, and PII permits a balancing act, particularly in cases where the allegations are extremely serious. And so any harm to national security, including a class-type claim, must and it's a mandatory requirement, must directs the judge to exclude that material from the open material before the court, and it can only be dealt with in a closed material procedure. And that's the difference.
Well, we can't be concerned with whether Section 6, subsection 7 was complied with, can we? I mean, that's a separate issue.
No, I'm not saying it was or it wasn't, or that it wouldn't be. I'm simply identifying that there is, in my submission, a difference between these procedures. That if PII is considered first, the court will go through the process which has been discussed today. But under the Justice and Security Act, there is no requirement to do that, and it doesn't, for reasons I'll explain, come out of the wash in another way.
Well, the court has to be satisfied that the Secretary of State has thought long and hard about whether PII is appropriate. And I suppose in an extreme case, if you were satisfied or if you contended that the Secretary of State couldn't possibly have concluded the way he did, couldn't possibly have paid sufficient attention to that question, that would be reviewable, wouldn't it?
Well, that's a different question of whether the Secretary of State has acted irrationally in reaching and in having that long and hard think. Is a very different question from whether PII would in fact work. And that's why I showed you these, showed my lord these submissions of my learned friends before the Divisional Court, where they set out the case law on this point in opening. And the case law goes quite a long way towards saying that there is no requirement to do a quasi-PII process, and there may be cases in which PII would lead to a successful and fair trial, where the case would not be struck out, applying Carnduff, or go one way automatically, applying Rossminster and Haralambous, but nonetheless, a CMP would still be available.
Yes, your basic submission is perhaps a complaint about subsection 7 as it being extraordinarily weak.
Well, I've got no right to complain about how Parliament has chosen to introduce a closed material procedure, but because Parliament is sovereign and can do whatever it wishes. But when construing Parliament's legislation and deciding a jurisdiction question of whether or not Parliament truly intended to put this kind of case within that kind of procedure, I submit I am entitled to say that the court ought to proceed cautiously before deciding that such a serious interference with natural justice is one that Parliament truly intended, and that it has, as Mr. Eadie put it, gone through the rigours of the democratic process, because the appellant's submission is that it hasn't. All Parliament did was to use a term, criminal cause or matter, which, to the extent it had a well-established meaning, is well established that a judicial review of a decision to prosecute or not to prosecute is within the scope of a criminal cause or matter. So the rhetorical question, I accept it's rhetorical, is how has Parliament truly said and accepted and confronted the implications of removing the right to natural justice in these circumstances? The appellant's submission is that Parliament hasn't done that. And that leads on to the principle of legality issue, because that's what I say the proper test is. But when considering that test, I invite the court not to start from the assumption that the Justice and Security Act is a complete code for the resolution of all problems which arise in relation to sensitive evidence. Because it's not. Parliament was absolutely intending to leave serious problems unresolved in relation to the Justice and Security Act. And the most obvious example of that is the example which my Lord Mance put to Mr. McGuinness a moment ago, which is as soon as you take the word terrorist out and replace it with drug trafficker, then the Act provides no solution, but the dilemma still exists. The core difficulty in my submission with the submission on behalf of the Secretary of State is it doesn't in truth successfully explain at any point what the words criminal cause or matter actually mean. Mr. Eadie is prepared to accept, for the purposes of argument at least, that extradition is a criminal cause or matter. Now, there's various ways of conceptually defining extradition, but ultimately it's a decision to transfer someone out of the jurisdiction for the purpose of them undergoing a criminal trial in another country. It's very closely analogous, of course, to a prosecution decision. It's a decision by the appropriate authorities of this country that someone ought to stand trial, taking into account the human rights compliance of that other country and their prospects of receiving a fair trial there.
Well, ought to stand trial or ought to serve a sentence if they've been convicted.
Yes.
So I suppose the Secretary of State's proposition is that even if you... Yes, well, he accepts that, that's all she accepts.
Then one asks, well, what exactly is the difference between an order committing someone to a criminal trial abroad and the issue here, which is an order committing someone or not committing them to a criminal trial here? Why is one of those things a criminal cause or matter and not? And is that clear against the position of the appellant? Well, the appellant's submission, it's not. And to do it, as Mr. Eadie does, is, in the appellant's submission, actually the wrong way of interpretation. What we don't do is to look at the green paper and say these are the hopes, dreams and desires of ministers, which were extremely wide. They weren't just national security, they were sensitive information, and their definition at the time was criminal proceedings, not criminal cause or matter. And shall we see if we can construe the Act as broadly as we possibly can so as to maximise the scope of closed material procedures, so as to achieve that object. What there isn't is any indication in the text of the legislation that Parliament was signing up to objects which were anywhere close to that broad. To the contrary, Parliament was not providing a complete code, as I've suggested. Can I briefly deal with some of the authorities that were cited in my learned friend's submissions? Evans, first of all. Evans is in the supplemental authorities bundle at tab 68, MS 2209. We've checked, and Evans wasn't cited in Al-Rawi. Probably should have been. It was an example. It is an example of a closed material procedure in a judicial review by consent, and that consent is recorded at paragraph 8 of the Divisional Court's judgment. And what they say is interesting because it's apparent from paragraph 8 that they also carried out a PII process. They carried out PII, they worked out what could safely be disclosed, and it looks like it was a counsel-only confidentiality ring, and some material was put into that counsel-only confidentiality ring, and in respect of the rest of it, Mr. Evans consented to a closed material procedure. Perhaps the reason why it wasn't cited is that although the court expressed differing views in Al-Rawi, the parties in Al-Rawi were as one that consent was a possible solution. My learned friend also relied on the decision of Mr. Justice Ousley in AHK. AHK is at volume 1, tab 8, MS 68. Where this case fits into the timeline is that it's after the hand-down of judgment in Al-Rawi in this court, but it's before the Justice and Security Act. And it concerns a large group of refusal of naturalisation judicial reviews, which Mr. Justice Ousley was managing. And there's a useful discussion of how PII works and how it's different from a closed material procedure at paragraphs 32 to 51, which is MS 75 and onwards. And that's where I draw the submission that PII, or authority for the submission that PII will consider the seriousness of allegations, and that's an important part of the balance, whereas that doesn't occur in a closed material procedure. I would add there's nothing special about the Justice and Security Act closed material procedure. In all closed material procedures throughout the statute book, any harm to national security, no matter how minor, leads to the exclusion of material. Class claims are permitted, and PII does not need to be tried first. There's nothing magic about the JSA in that respect. That's the position in respect of control orders, TPIMs, asset freezing, SIAC, the Employment Tribunal, national security provisions, and so on. Mr. Justice Ouseley then deals with the issue of consent from paragraph 88 onwards. And I do need to deal with this because the position of the Secretary of State, contrary to that in Al Rawi, is that consent is no longer possible. That was also Mr. Justice Ouseley's provisional conclusion. He describes it as tentative. Paragraph 89, he says that arrangements for consent would be unfair to defendants because why should we assume that a defendant would usually consent? Well, it's the claimant's decision, and I'm using the stereotypical example. I know it can be the other way round, at least in principle, but it's the claimant's decision to absent themselves from a hearing voluntarily that we're talking about. If the claimant chooses to do that, the defendant no longer has any good basis in respect of public interest immunity to withhold the material, because by definition there can be no harm to national security that flows. Disclosure to the judge can't cause any harm to national security. Disclosure to a specially appointed advocate, appointed by the Attorney General, who has a high level of security clearance, can't cause any harm to national security. It's only disclosure to the public or to the claimant that causes a difficulty. And so in those circumstances, it's not a question of the defendant being asked to consent. It is the claimant's decision to absent themselves, and then the court applying the PII balance with that in mind, which is a fairly straightforward balance. So my respectful submission to this, Justice Ouseley, is that's a misanalysis. Then paragraph 90, he said the court would have to make some rules and there would have to be procedures about the scope of the closed material procedure. Well, that's not an insuperable problem because closed material procedures do exist in the law already. They occur in some family proceedings without the necessity for statutory authorisation, and they occur in litigation where the very object of the litigation would be destroyed if one party were to be given access to the material. And they were recognised as exceptions in Al Rawi. Paragraphs 91 and 92 deal with the concerns which were expressed in this court in Al Rawi by Lord Hope and Lord Kerr about consent, and the analysis there essentially adopts the response given by my Lord, Lord Mance. Then paragraph 93 raises some more practical problems. Says that the claimant would have to be advised that the case is arguable to the extent that it was worth having a closed material procedure. Then Mr. Justice Ouseley goes on to say, well, the judge can't do that. Maybe the special advocate could do that, but the Secretary of State might object to the disclosure which would be required for that purpose. Well, in practical terms, that's not a problem because it occurs all the time in relation to closed material procedures where there's the possibility of an appeal in respect of a closed judgment. What happens when a judgment is handed down which is adverse, where there's been a closed material procedure, is the advocates for the individual who's affected send an email to the special advocate, says, dear special advocates, do we have any arguable grounds of appeal? And if they're sensible, they also say, and please give a yes or no answer, and please be as sensible as you can, because we don't want to waste everyone's time if it's completely hopeless and closed. The special advocates then apply for permission to send a communication, and the communication contains the word yes or no, and nothing else. And that's how it's dealt with. And then if the answer is yes, you have an arguable ground of appeal, then the individual will file a notice of appeal, which is blank and says the special advocates will supplement this enclosed. We've got no idea what the grounds of appeal might be, but we're going to let the special advocates deal with it. So those type of procedures are already in place and they work perfectly well. Then I think that's more or less it in relation to the analysis. So although it was only tentative analysis, and obviously it's not binding, my respectful submission is that those concerns are not ones that are ultimately particularly powerful. Mr. Eadie then says, well, after the Justice and Security Act, surely that occupies the field, and there can't be any place for a closed material procedure since the Justice and Security Act has had that effect. Well, you already have my submission about the extent to which the JSA does occupy the field. It was meant to be a limited and partial solution. Parliament might well revisit it in the future. It might go one way, it might go the other way, but this was not intended to be a comprehensive solution. Mr. Eady then cited Fawaz and the Fawaz litigation. My Lord Mance asked if there was more detail about the facts. We actually have the substantive judgment in the bundles, which sets out the facts in detail. I'll just give you the reference. It's Authorities 3, tab 30, MS 883. But it is, as Mr. Eady described it, it's a letter of request case. Can I just turn up briefly, though, the judgment of Mr. Justice Wynne Williams, which is in Volume 1 at tab 9, MS 91. This is a case where the claimant consented to a declaration being made under Section 6. So the criminal cause or matter issue was not disputed between the parties. One suspects that one of the reasons for that is that in the United States, where there was criminal litigation going on, they actually have a very different approach to criminal proceedings, and there is legislation which permits security-cleared defence advocates to be shown some material relating to the defence that they are not permitted to pass to their clients. Now, there are strict restrictions over that, and there are limits for obvious fair trial reasons, but nonetheless, there is a class of material that can only be made available to an advocate and not to their client, which creates all the usual obvious professional conduct problems, but nonetheless, that's the position under US law. So in those circumstances, one can see why consent was given. But nonetheless, the analysis of Mr. Justice Wynne Williams is at paragraphs 6 and 7, and the key part is at paragraph 7, where accepting the submissions made by counsel for the Secretary of State, the judge adopts a purposive approach to the interpretation of Section 6 and says it would be unfortunate if this case was excluded from the scope of a closed material procedure because the real decision that's under consideration is whether the Secretary of State exercised her discretion properly. Well, you already have my submissions as to why that's not the right approach as a matter of law. First of all, the issue about the principle of legality was not raised or considered. But also, it doesn't deal with the fact that the authorities in relation to criminal cause or matter do not look at the function of the court in the proceedings before it. They look one step down at the nature of the litigation with which it's being concerned. So my Lord Sumption referred to the habeas corpus cases. One of them is Amand, which is in Authorities 1, tab 11, where that's precisely what the court did. Habeas corpus is civil, but nonetheless the issues in the application for habeas corpus arose in the context of criminal proceedings, and therefore it's a criminal cause or matter. Now, I don't think it's necessary for the appellants to comment on whether that decision is right or wrong, because on that issue, we're right within the scope of the difficult and interesting area of criminal cause or matter. But the mode of analysis which was adopted by Mr. Justice Wynne Williams, I suppose, is not one that the court ought to adopt or follow. My learned friend then relies on Haralambous. Haralambous, as the court knows, is a case which is quite similar to Bank Malat, that there's legislation which provides for an ex parte process, and that means, by necessary implication, if there's going to be a judicial review of a decision made by the judge in that ex parte process, then it's going to be necessary to be able to have some form of closed material procedure, because otherwise you would entirely undermine and frustrate Parliament's intention in permitting the magistrate to proceed ex parte in the first place. No part of my case to quarrel with that analysis. The question here is entirely different in my submission. The interesting feature of Haralambous, though, is that what the common law courts have done, and this is recorded in my Lord Mance's judgment at paragraph 22, is even before the judgment in Haralambous, the magistrates' courts and on judicial reviews and appeals had grafted onto that process PII. So when someone's house gets raided and they then are prosecuted and they wish to complain about the execution of a warrant against their house, they can say, I would like to see the information that was placed before the magistrates. And the magistrates will then, pursuant to a series of authorities which are cited in the judgment, conduct a PII process. PII comes first. If that PII process fails and there is material about which the judicial review can't be fairly determined, then, by necessary implication, the court will permit a closed material procedure in the judicial review. But it is interesting to note that PII comes first, and there's also commentary in that case about how the strength of the PII application may depend on the time it's made. If, for example, there's still an ongoing criminal investigation, other suspects may still be to be apprehended, there are other investigations going on in the same sphere, the PII application may well succeed when it's made on behalf of the Crown. However, if, for example, there's litigation about the lawfulness of the warrant, various tortious claims brought 3 or 5 years after the event, all the investigations have come to an end, there's no ongoing concern, then the PII balance is likely to be struck differently. And so the amount of information that will be disclosed will depend on the time and the circumstances. And that's the advantage, again, of PII. It's a flexible common law approach and a flexible common law remedy. So rather than Haralambous not being of assistance, the appellants submit that Haralambous actually supports their case. Then, very briefly, Mr. Justice Popplewell's decision in the civil proceedings. I'm not going to take you to it, but first of all, it wasn't appealed. Why was it not appealed? The reason is because Section 7 comes next, and the Section 6 proceedings were only conducted on the basis of a sample of the material. The same test has to be reapplied by the judge once he has all of it at Section 7. As a matter of sensible case management, it would be a bit silly to bring an appeal in relation to Section 6 now, especially in a case that's already been going on, I think, for 7 years since the claim form was issued. In those circumstances, to the extent there's going to be a challenge to that decision, it's going to happen at the Section 7 stage. And Mr. Belhaj and Mrs. Boucher have made that clear. That's the reason why they're not appealing that point at the moment. Just to deal with the content of Mr. Justice Popplewell's analysis, the key point here is that in the civil proceedings, the application is being made on the basis of entirely different material than is before the divisional court in this case. The only 3 documents over which the closed material procedure is sought to be adopted are the decision documents of the 3 people who considered the case: counsel, the decision maker, and the victim's right of reviewer. In contrast, in the civil proceedings, the actual primary evidence is going to have to be disclosed. And the reason for that is that the target in the civil proceedings, where the court will be making its decision for itself on the facts, and the target in the judicial review, which is about the rationality of the analysis in those documents, is completely different. And it's obviously also the case that not all of those 3 documents will need to be disclosed. And so the extent to which we can gain assistance from Mr. Justice Popplewell's decision in relation to the civil proceedings is, in my submission, quite doubtful. 2 final points. First of all, the principle of legality. What is being said is that the rights, by Mr. Eadie I should add, that the rights are being balanced here within the closed material procedure. And because Parliament has provided safeguards, then in those circumstances, the court doesn't need to worry too much about the principle of legality, or its application should be attenuated in some way. My submission in response is that's not the correct way to approach the principle of legality. First of all, Parliament was told pretty clearly in Al Rawi that the court would not readily assume that these fundamental rights were being abrogated. So that's a clear hint there. And the fact that Parliament has decided to legislate for some encroachment into the principles of natural justice does not mean that Parliament intended that encroachment to be read more widely, because we know that Parliament was intending a tailored solution which didn't go further than it needed to. And I mentioned in opening the recent decision of this court in B. Algeria. I didn't show it to you, but I do commend it to you on this point. We don't need to turn it up, but it's volume 3, tab 33, MS 928. that was a case where there was a question of whether or not bail conditions could be imposed in circumstances where someone had been unlawfully detained. And all of the familiar arguments were put before the court that what Parliament was doing is it was trying to balance the grave risk to national security of releasing somebody without any bail conditions. They couldn't be tagged, they couldn't be monitored, they didn't have to report to the police station, and all of that, as against the argument on behalf of B, which was one squarely based on the principle of legality, which is that in circumstances where there is no power to detain me, how on earth can this legislation be construed so as to permit bail conditions to be imposed? And to the extent there is any doubt, it needs to be resolved in my favour. And like this case, it's a jurisdictional threshold question. What the court is doing is the court is saying, well, look, someone is being unlawfully detained. Should we purposively construe the power to grant bail conditions so as to protect national security by allowing bail conditions to be imposed? Or do we say, well, if they're being unlawfully detained, how can there be power to impose bail conditions? And the answer is one which, in my submission, the court reached was entirely correct. And as applied here, what it means in practice is that the principle of lawful conduct by public authorities is upheld, and if Parliament wishes to be able to say that even where someone is unlawfully detained, SIAC may call them in and impose some bail conditions because they have a case before SIAC and because they therefore may pose a risk to national security, then Parliament can come back and say so. But it's not for the court to remove those rights, even though one can see the very strong pragmatic argument for including a right to impose bail conditions on people in that class. Finally...
You are way over time, Mr. Jaffe.
Okay. In that case, I'll make one more point relating to my old friend Mr. McGuinness's examples. Under A, the suggestion was made that a confidentiality ring is impossible in a criminal trial. I wasn't suggesting a criminal trial. I was suggesting a judicial review. Mr. Eadie was proposing them as well, relying on McGartland. Example B, Ripper. Mr. McGuinness has missed the word or in section 18.7. Part of that provision deals with criminal trials. The other provisions deal with all cases. And subsection 9 deals with the process in criminal law. In civil law, the way it's dealt with is by the duty of candour in judicial review, which requires the disclosure, which is only limited by section 17.1. On the final example, which I think we all agree relates to this case, the appellants are still waiting for an explanation of why this can't be dealt with under PII, given the abandonment of neither confirm nor deny in the DPP's decision. None was offered. Unless I can be of any assistance, and I apologise that I've run over.
I think not.
I'm grateful.
Nobody's got any more questions to ask. Thank you very much indeed. And thank you to everybody for their very helpful arguments in this puzzling dilemma. And we will now go away and work out what we think the answer might be. The court is now adjourned.